Good morning. I'm just jealous.
Good morning. We are on the record. Today is Monday, March the 5th, 2018, and this is the Cosmetology and Barber Examiners Board meeting. We posted notice of this meeting on the board's website on March 1st, and so we are ready to proceed with the legal report. I will turn it over to our litigating counsel, Pamela Spicer.
Good morning, everyone.
Hello, Pam.
Good morning.
Thank you for being here this morning, too.
Oh, no problem. I know you all have the legal report on your iPads, and I know that right off the bat we need to discuss number 1. It's marked for discussion. Do you want me to go ahead and start with that one? Okay.
Well, can I just get one thing out of the way
Yes.
first? Because the only other question I had in this packet, thank you, was cases 37 and 38. And I assumed that was the same shop. But I wanted to clarify maybe if one was for the shop and one was for the manager, or...
Let me look at it.
Or are those two
No,
different?
Those are two different shops.
Okay, and one was the $100 fine because the license was expired, and the second was a $600 because the license was expired and there was no manager. Okay,
Right.
that makes sense.
Yes, so two different shops.
Got it. Thank you.
Well, since we're doing that, on case number 25, it was regarding a school. Just a comment, there's not really a question, but I didn't think it was pertinent for the record. It regarded, I believe, someone wanting to see student records. You may not know, but there are federal regulations that apply here for privacy rights for students. The federal code is FERPA, Family Educational Rights to Privacy Act. It's very much like HIPAA, if you're familiar with that in the medical side. So a school can't just disseminate information about students. They have to have a written request and a authorization to go along with it. Okay.
Do you want me to move to number 1? So this is a manicure shop. We're basing, the complaint is based on a consumer complaint, but we did perform an inspection. 3 persons were found to be unlicensed. The issue is this salon's only been licensed since 2016. They expire the end of this month and would be subject to renewal. To my knowledge, they haven't renewed yet. But in 2016, they had a $7,000 penalty. It does say for unlicensed activity, but I did go back and check that complaint. There were 6, not 7 unlicensed individuals in the 2016 complaint, and then they got hit for some other things as well. But the concern is they've only been licensed since 2016, and now we have a total of 9 persons working unlicensed. So I wanted to give the board the option to discuss this because I can only penalize them up to $1,000 per unlicensed individual. So the penalty for this new complaint would be $3,000. Or the board could have the option to move forward with a request for revocation. Of course, one issue is we probably can't have a hearing before March 31st of this year, so they would be subject to renewal. And I spoke to Roxanne. I don't think we can stop that renewal from happening, but we could still go forward with revocation if the board votes for revocation, or this is their second strike within 2 years. I don't know whether we hit them with a civil penalty of $3,000 with language that says if you do this again, we'll seek revocation, or do we go forward with revocation now?
They've already had a $7,000 penalty. And
Correct. That was in 2016, not long after they were licensed.
Write us a check?
Hmm?
Did they
Yes.
just write us a check?
They did.
Cost of doing business.
It is. Clearly.
And if Frank was here, he's the only board member that let me know in advance that he was not coming in. So I hate that because his philosophy is that some businesses just include it as cost of doing business. And I think we tried to, for consistency, state that when we have that unlicensed situation, the people running out the back, the big numbers of unlicensed, it's that third strike and we close them. I think this is a little unusual just from the almost zero history. I mean, they've just gotten their license and we're seeing this. So.
Well, my guess is if you sent out another inspection, you'd have your third strike pretty quickly, unfortunately. I don't know. I don't know if I feel comfortable following the rules or because the rules have so clearly not been followed that we just move forward with what possibly is the inevitable.
The board has the discretion. There's nothing written in stone that says that under different circumstances you can't go for revocation or something different.
Correct.
Exactly as Pam said, they would be allowed to renew. There's no way that we would be able to do anything fast enough, and we can obviously attempt to inspect one more time. We may be getting at the same situation. I mean, this originated from consumers being concerned. That's the reason we went.
Being a consumer complaint, you know, it has a little bit different weight in my mind, at least, than if
be consistent with the three strike kind of thing. I almost would like to see the inspector go back out and see if we continue to.
we have an option of suspension.
We discussed that. I do not think that we could go forward with a summary suspension based on the language that I have to prove in order to meet the level of a summary suspension. We could, if this makes everyone kind of fuzzy, I guess, we could do a $3,000 civil penalty, send the inspector back out because they're up for renewal. Not that we would necessarily have to give a reason, but send the inspector back out. If they find unlicensed individuals again, then we move forward for revocation. Or you can move forward for revocation now. I was only mentioning the three strikes. There is definitely no rule that says that. I just wanted to remind the board that not necessarily in this situation, but in situations, we do have guidelines of how we assess civil penalties, and we have in the past, not necessarily with this fact pattern, but with other fact patterns, it is sort of like a three strikes and you're out.
Well, and the three strikes have certainly been over a longer period of time than
Correct.
a shop that's only been open for, what, almost 2 years? Not quite?
Yes, and that's our concern, is that we're talking about a shop that's only been open since 2016.
And not necessarily just someone who had one individual in there, which could be an oversight. This looks like a pattern.
Correct.
You know,
I'm sorry, go ahead.
we don't ever take a revocation lightly. That's just a big, heavy hammer to use. But
And that's why I wanted to bring it to the board's attention, not make any assumptions, and let you all discuss it, how you want to go about handling this particular complaint.
I think if the owners of this shop were sitting where y'all are today, I would feel better knowing that we'd gone back a third time to say that, you know, over the course of the years that I've sat on this board, that's been more or less the process that we've followed. And unfortunately, you know, with being caught twice in less than 2 years, it absolutely warranted another inspection. And you're right, it's the renewal. And I think then very clearly I would be surprised if there was not unlicensed activity during that inspection. I think we always know once we have our inspections, then we quote unquote have a grace period where we know the inspector isn't coming back.
Correct.
Not in my world, though. My inspectors seem to show up all the time, and we love them. Do yours?
all the time.
Okay, yeah. I mean, yeah.
I've had them come twice or in the same week. Or,
We have too. Not that we're complaining.
No.
I think they like our coffee.
So
are we leaning more towards the fine at this point and then send the inspector back?
That's what I would be most comfortable with, I think.
Okay, so we will, the recommendation will be a $3,000 civil penalty, and I will have the inspector go back out, do a new inspection. Hopefully that can be scheduled. I don't think that would be a problem before the end of this month, and then we'll go from there once I see what we get. A new complaint will be opened, and at that point, my recommendation would likely be, it doesn't matter if it's only one person, it would be for revocation.
But I think we can clearly say we've not deviated from our process so far, and we've given them all the chances in the world to get their act together.
Correct. That's all I have, unless you all have anything else on the legal report.
I had one question about case 23. It was a school who opened before the inspection. I just wanted to know, are those students' hours still going to count?
Question for Roxana.
They are. This particular school was changing location and really thought because of the move that everything was in line, but to be consistent with what we do, we had to open a complaint. So, yes, the hours would be counted. They were taught by instructors that are licensed, followed all the right protocols, so they would not be hurt.
Okay. I just wanted to make sure that the students didn't feel that.
Absolutely.
Okay.
Absolutely. Good question.
Anything else?
Okay.
Thank you.
Thank you. We will reconvene with the full board at 10 o'clock. Thank you.
Traffic was special today, y'all.
Good morning.
Morning.
Morning. This is the Cosmetology and Barber Examiners Board meeting. Today is Monday, March the 5th. Notice of this meeting was posted on the website on March the 1st. Chairman Gillihan, I'll turn it over to you.
Good morning, everybody, and thank you for being here. We'll always start the meeting by having a roll call.
Thank you. Ms. Kelly Barker?
Here.
Mr. Jimmy Boyd?
Here.
Miss Anita Charlton?
Here.
Miss Nina Coppinger?
Here.
Mr. Ron Gillihan?
Here.
Miss Brenda Graham?
Here.
Miss Yvette Granger? Miss Judy McAllister?
Present.
Miss Patricia Richmond?
Present.
Miss Becky Russell?
Here.
Miss Mona Sappenfield? Miss Amy Tanksley?
Here.
Thank you. And Mr. Frankenbusa had let me know he would not be able to join us today, so everyone is here. Thank you.
We'd like to take just a minute and welcome our visitors in the audience and our guests. It's kind of our custom here to always recognize the different schools that come down to visit. We know it takes a lot of effort for school folks to get here, so if you would one person from each of your schools just stand up and tell us who you are and where you're from? Yes, ma'am. Thank you for coming. Yes, sir.
University of Barber College, Smyrna, Tennessee.
Welcome. Good to see you. Yes, sir. Paul Mitchell, Murfreesboro, and Knoxville. Okay. Yes, ma'am. Thank you all for being here and taking part in the process. Just in case you wondered why we were all just sitting around and chatting for all this time, we weren't wasting your time, but we do have an agenda and a schedule that we have to follow. We really can't move things up and down too far, so there was a purpose behind it. Okay. If we could, we need to move on to the approval of the meeting minutes for January 29th, 2018. Are there any additions, corrections, or deletions? If not, do we have a motion to approve?
Make a motion to approve. Second.
We have a motion and a second to approve the minutes. All in favor say aye.
Aye.
Opposed say no. Motion carries. Ms. Roxana, we're up for the legislative updates.
Thank you. You have on your iPads, I believe it is a total of 59 pages. These are the legislative updates that have been filed through Thursday, which was March the 1st, and I'm going to turn it over to our attorney, Sherelle Hooper, for her explanation, answer any questions, and we will continue after that.
Good morning.
Morning.
Good to be here with you all. I think you all received a copy of these bills prior to the meeting. Wanted to go ahead and start with House Bill 1809. House Bill 1809 is currently before the House in the Government Operations Committee, and it's scheduled for March 7th, 2018. It's also in the Senate before the Commerce and Labor Committee, scheduled for March 13th, 2018. 1809, this is the bill we talked about at the last meeting. It combines the disciplines of barbering and cosmetology by eliminating licenses under the barbering discipline and creates uniform cosmetology/barbering licenses for individual licensees, shops, and schools. This bill deregulates natural hairstyling by eliminating the requirement for a license to perform natural hairstyling services and eliminating the requirement for specialized shops and schools to be licensed. For rulemaking purposes, this bill takes effect upon becoming law, and for all other purposes, this bill takes effect on January 1st, 2019. Now, there have been a number of amendments filed to this bill. I believe there are 4. And some of these amendments overlapped or conflict with each other to some extent. And so I just want to make sure you all are aware of that as you try to kind of understand what the different amendments mean. The first one I'm going to discuss is Amendment 013188. And what this amendment does, in addition to the changes made by the original bill, it removes the requirements related to hair wrapping. And so they no longer have to post a notice that they are not licensed or that and they're not required to obtain the 16 hours of education prior to engaging in hair wrapping. This amendment clarifies that a residential cosmetology/barber certificate is not necessary if the services provided are under another exception. It also clarifies that a barber shop is not required to meet the requirements of a cosmetology shop as far as the physical dimensions if they previously met the requirements before being converted to a barber/cosmetology shop. Next amendment, amendment number 13777, it creates a requirement that an individual must complete at least 100 hours of training at a natural hairstyling school or a school of cosmetology in order to use the title, quote, certified natural hairstylist, end quote. Next amendment, Amendment 013856, deletes the high school diploma and GED requirements for master barbers and barber technicians. It does not change the requirement that cosmetology students complete 2 years of high school or have a certain GED score. In addition, it removes the requirement that master barbers, as well as cosmetologists, manicurists, estheticians, and natural hairstylists have 3 continuous years of licensure. It would allow these individuals to become instructors after at least 3 years of licensure in general. This amendment creates a new type of cosmetology shop referred to as a braiding salon. It also defines hair braiding and creates a braiding license. The braiding license would require an application and an examination as well as fees for such. To qualify, an individual would need to show that he or she has passed a course of instruction in practice and theory consisting of minimum sanitation practices, theory of hair, and conditions of the scalp. It does not specify the number of hours and leaves that decision to the board. This amendment substitutes the language natural hair for natural hair care and redefines natural hair care styling to include having an understanding of the conditions of the scalp as well as techniques involving hair cutting, thermal styling, and roller setting. It also omits the words or other preparations, which may have the effect of natural hairstylists being able to use techniques that involve the other preparations mentioned in connection with dyes and reactive chemicals in Tennessee Code Annotated 62-4-102A16. This amendment would require the board to develop a detailed plan for merging the practices of barbering and cosmetology and deliver such by 2021.
one amendment? What you just read?
Now, these are 3 different amendments.
Wait a minute. Did I hear this right, that this bill is proposing to deregulate natural hair license, to get rid of the natural hair license, and then the amendment says creating a braiding license?
Yes, one of the amendments proposes that.
Oh.
And I think Sherelle might have said, but the amendments do sort of contradict
Yeah,
each other.
that's
So,
right.
you know, they will be sorted out. They're being heard and.
So next we'll discuss another bill. This is House Bill 2551, Senate Bill 2712. It is currently assigned to the Business and Utilities Subcommittee in the House, and it has passed on second consideration in the Senate, and it's been referred to the Commerce and Labor Committee. There hasn't been an update, though, since early February, so not clear on how this bill will proceed. This bill also deregulates natural hairstyling by eliminating the requirement for a license to perform natural hairstyling services and eliminating the requirement for specialized shops and schools to be licensed. This bill expands the definition of natural hairstyling to include the use of decorative beads, fibers, or other accessories, minor trimming of natural hair or hair extensions, the making of wigs, and the use of topical agents. Furthermore, it defines mechanical devices that natural hairstylists may use to include curlers and curling irons, as well as other items. It adds a restriction that natural hairstylists cannot use chemical hair joining agents. This bill also eliminates the 16 hours of training and certificate required for hair wrapping, and it would take effect upon becoming law. There are no amendments with that one right now.
This is not a license. This is a definition?
With House Bill 2551, what it's doing is eliminating natural hairstyling, but also defining what qualifies as natural hairstyling. So it's expanding the definition while deregulating.
Deregulate and then create just certifications? Are we going to regulate? I mean, are we regulating that? Will we hear from those people? I don't understand that portion of it.
Well, that particular bill does not create a certification to my knowledge. So what it does, it gets rid of the certification for hair wrapping. So that's 16 hours of education and certificate for hair wrapping. It also deregulates that as well. But it doesn't create any certifications, and I'm referring to House Bill 2551.
But the other House bill did. That's what I was wondering, the same thing. Who?
North.
Yeah.
I mean,
Who's proposing this bill?
I'm sorry, which one are you referring to?
Both of them. Is Hawks doing the first one?
The first one,
Hawk
House
was
Bill
behind.
1809, is Representative Hawk and Senator Norris. And the second one, House Bill 2551, is Representative White and Senator Bowling. Now moving on to House Bill 1483, Senate Bill 1888. This bill is currently on the calendar for the Business and Utilities Subcommittee for March 6th, and it has passed on second consideration in the Senate, and it's been referred to the Commerce and Labor Committee there. So what this bill does, it creates a new continuing education requirement for master barbers, barber technicians, cosmetologists, estheticians, manicurists, and natural hairstylists. It requires that such persons complete 5 hours of continuing education biennially as a prerequisite for renewal. It would also require that a barber technician who has let their registration lapse for more than 1 year provide proof of continuing education even though they must retest. Curriculum is to be determined by the board through its rules. And for rulemaking purposes, this would take effect upon becoming law, but for all other purposes, takes effect effect on July 1st, 2018, and relates to renewals occurring on or after July 1st, 2020. And there are no amendments that I am aware of to that particular bill. And that bill is from Representative Staples and Senator Tate. Next bill.
Sorry. That's the one we discussed last time that, would put in a requirement that doesn't exist right now, and that we'd have to figure out what would constitute the requirement of 5 hours biannually. So,
Yes, that's correct. The bill does say that the board would prescribe the curriculum, so that would be one of the board's duties should this become law. The next bill, House Bill 1630 and Senate Bill 1552. This is from Representative Faison and Senator Bell. This bill is currently on the calendar for the Government Operations Committee for March 7th, and it's been. And then it's also already passed in the Senate, and it's now sitting with the House. And this is just the sunset bill. It extends the board for 4 more years to June 30th, 2022. The next bill, House Bill 2059, Senate Bill 2293, and that is from Representative Parkinson and Senator Bell. This bill is currently referred to the Calendar and Rules Committee, and it's passed on second consideration in the Senate and referred to the Senate's Commerce and Labor Committee. And this bill makes multiple changes to the current educational attainment prereqs for licensing as a barber or cosmetologist in Tennessee. What it does is delete the requirement for a high school diploma or its equivalent for barber technicians, master barbers, barber instructors, and cosmetology instructors. It also deletes the requirement for barber instructor assistants to have completed the 10th grade in an accredited school or its equivalent. Finally, this bill deletes the requirement that a barber instructor or cosmetology instructor be licensed for 3 consecutive or continuous years prior to filing an application, as long as they've held a license for 3 years non-consecutively or consecutively, they'll be able to obtain an instructor's license, and this would take effect on July 1st, 2018. And there are no amendments to that bill that I'm aware of at this time. Next bill is Senate Bill 1930, House Bill 2546, and that's Senator Massey and Representative White. This bill is currently it's passed on second consideration in the Senate, and it's been referred to the Commerce and Labor Committee. It has passed. It's been placed on the calendar for the Business and Utilities Subcommittee in the House for March 6th, 2018. And this bill requires that the board promulgate rules related to timely notifying respondents of complaints and creating a statute of limitations similar to those under the Tennessee Real Estate Broker License Act of 1973. This bill would take effect on July 1st, 2018, and essentially that just deals with when individuals are notified of complaints and having a certain amount of time under which a complaint would no longer be valid, essentially, against a licensee or otherwise. And there are no amendments to that bill that I'm aware of. The final bill that affects barber cosmetology is House Bill 2537, Senate Bill 2458. And that's from Representative Howell and Senator Roberts. And this bill would require that the department accept a 6-month apprenticeship registered with the U.S. Department of Labor in lieu of professional education and experience requirements for any licensed regarding a program attached to the Regulatory Board's division, so long as the applicant has completed the 8th grade. The applicant would still be required to pass an examination if otherwise required. The bill states that the Division of Regulatory Boards shall establish a passing score for each profession. The bill states that a person shall be able to apply for an apprentice status only once. It would take effect immediately for rulemaking and on July 1st, 2019 for all other purposes. That bill, even though it's generally applicable, because barbering and cosmetology fall on the list of apprenticeable professions, it would impact the licensees of this board such that professional education wouldn't necessarily be mandatory if this became law.
Another question, because which one rules? I mean, we have rules on apprenticeship in laws, so they're going to make new rules just by date. Which one are we going to follow? Would this supersede what we've done in the past? Or, I mean, pick which one? Or it's very confusing.
I think practically, if this bill were to become law, we would be obligated to revise our rules to essentially create what this creates, which is a sole apprentice track for licensees to become licensed without school requirements.
If our definitions are law, do we have to wait for another legislature to approach that, or are definitions rules, and that'll be the board's responsibility to just rewrite the rules?
Well, I think if it became law, because, we're required to implement the laws, I think it would just be an affirmative obligation that we, in our legal division would see a need to go ahead and revise our rules to be consistent with the statutes, because the statutes, take precedent over our rules, because our rules are designed to implement those.
So far, just what you've gone through, I noted there are like 4 proposed new laws, they're not law yet, that are actually stating that the board would be responsible for the rules, and by these certain dates. I think that's an unnecessary burden on this board. It took us quite a while to write rules over the past 6 years that we've been here, and most of us have a full-time job. I mean, I don't understand. This would be a very burdensome legislature.
I definitely understand. There are some emergency rulemaking options, depending on what passes and the urgency, depending on the time constraints. We may have to exercise some of those depending on what happens, but that is one mechanism to get rules in place. It's an emergency rulemaking process, and we'll just see what happens, and that'll kind of determine how we need to proceed, how I would guide you all as far as passing new rules.
Seems like if this last bill that was proposed passed, we won't be needing a board much longer, so I'm just going to hold out that it may not pass.
This last bill, can you just put it in the simplest of terms, because I still am not sure what it's even saying.
Okay, I think you're referring to the last one I talked about. It's House Bill 2537,
Yes.
Senate Bill 2458. And I think the easiest way to explain it is essentially it creates an option for an individual who wants to do an apprenticeship only to test for any of the licenses and become licensed without having attended a school program. So it leaves the option for individuals to go to school, but it creates a full apprenticeship path to the profession.
And we had already set the rules for the apprenticeship path that you had to take so many classroom hours and then test before you apprentice, right? That's how it's set up now.
It is, and there is a law that brings in that apprenticeship under half of the number of hours come in through a traditional school, half under. So I don't know that, again, if this passed, because it affects a lot of different industries. that it would necessarily get rid of that apprenticeship track. That could possibly remain an option, or someone could still want to go to school and do all the hours in a traditional school. This opens that option.
I agree with Roxana. I don't think it necessarily requires that what you have now that it be done away with, but I do think if this were to pass, this option would need to be revised in the rules. The rules would need to be revised to reflect this option if this were to pass. But I don't think anything else would change if a person wanted to complete all the hours at the school or do what you all have now, which I think is like a 50-50 apprenticeship and requirement. And so this would be another option for individuals.
Well, it gives a third option that's the path of least resistance, that people are going to go, oh, yeah, I think I'll do that.
Everybody. Yeah.
I wonder
Go to the
if
grandmother. Go ahead.
I wonder if, you know, states or whatever entities that have followed the path to just deregulation, no one needs a license at all for anything, if this is the path that it sort of goes on. If you don't need education, then do you need a license? I wonder if that's the path each.
It appears to me that whenever I look at some of these things that have been proposed together, they, not us, they are considering or about to remove any requirement that a student complete high school before they take on post-secondary education. So they're giving a high school student who is in the 8th grade, 14, 15 years old, the ability to find a path to employment that is kind of an end run around formal high school education. And then in the case of the apprentice program, if they're able to complete the program in 6 months, that has eliminated effectively half of the requirements, time-wise at least, hours-wise, for the education necessary. And it also removes any restrictions to have the person who is teaching them be anything other than just a licensed individual. So no additional education, no additional experience. If you've got a license and you want to take on apprentices, go right to it. So I'm not sure that this legislation is complete. Of course, these are just amendments. It hasn't made its way through the process. I'm sure smarter people than me may be looking at this to see how it actually lines up and can make it work together. I have concerns whenever we start offering to eliminate the need to complete high school before we move into secondary education or post-secondary education. I think that may open up some options to students that are unintended consequences of the legislation. I'd be concerned about.
I'm also very concerned that this legislation is putting Tennessee in a box, because all professions really would like to have mobility with their license. And how are other states going to see these limitations on education and just so many different levels? They're really going to have to examine reciprocity as people become more mobile, because maybe, you're just not going to live in Tennessee the rest of your life. Or if you would choose to live in Tennessee and you have a license in another state, which, we address that now, but this really changes the dynamics of mobility to all industries, all disciplines, that we represent on this board. And I think the legislature is really, that's just, some of these things are just not in the best interest of the direction that I think the Department of Commerce would be in favor of. Because we want people to go to work, but we don't want them to just be limited in their work. And that's not very progressive, in my opinion.
I think we can sit up here all day long and fuss about this and that and whine about what if and all this. But these people that are making these decisions, a lot of them don't know anything about cosmetology or barbering. They just think it's hair And so they're going to have something come through and go, sure. And not, I don't mean that in a bad way, but they don't have time to focus on every single piece of legislation that comes through there. And I think it's our responsibility as a board to contact our representatives to tell them our opinion about some of these. And I've already had a discussion with one of my representatives, a state senator up here, about the Parkinson bill 2059. And I mean, I think that's the only way. If any of these can be stopped, that's the only path we can take. And then again, some of them move so quickly and some of them change so quickly. And that first bill that she mentioned is bizarre. With all, I mean, that has so many different aspects to it. It doesn't even make sense. Plus, it contradicts itself. And so I think we just need to be vocal to our representatives. Every one of us has, we have different representatives up here, and we're going to have to, you know, let them know how we feel. And anyway, there's my soapbox. Can you just clarify one more time, House Bill 2059, the Parkinson one, about education? I want to hear that one more time.
It starts on your iPads on page 56, just so that
Okay.
Since you had almost 60 pages to look at, I wanted to kind of bring us all.
This bill deletes the requirements for barber technicians, master barbers, and barber instructors, as well as cosmetology instructors, to have a high school diploma or its equivalent. It deletes the requirement for barber instructor assistants to have completed the 10th grade in an accredited school or its equivalent, and it deletes the 3 consecutive / continuous years of licensure requirement, allowing individuals to become cosmetology or master barber instructors if they've been licensed for 3 years at all. So that it doesn't have to be consecutive, but it does have to be 3 years. And this would take effect on July 1st, 2018. So essentially it takes out the high school requirement and the 10th grade requirement for the barber instructor assistants. And then the 3 continuous years becomes 3 non-consecutive years. So it's still there. It's just that it doesn't have to be all at one time.
That's a rule we made recently, right? That you had to have 3 consecutive years.
A law,
actually,
and it added the word consecutive to barbers and continuous to cosmetologists, and so wanting to become instructor. It's all about the instructor.
Right.
And so what that did is if you didn't renew timely, it delayed, I want to say 4 or 5 individuals with a lengthy licensing history, but nothing continual because they just let it expire.
And let me clarify, it does keep the requirement in there that cosmetology school students have to pass the 10th grade. I think that's in 6224-122. It does leave that in there.
Barbers is 8th grade.
On the barbers, it is now 12th grade, I believe, to enroll in barber school. And it would take this back to the 8th grade.
I would actually need to look at the bill itself, but it deletes the high school diploma or
Right. This one does.
equivalent
On this
requirement.
one.
I'm not sure if it necessarily says the 8th grade. Thank you.
That's on page 59 at the very bottom. Successfully completed the 8th grade.
Yes, that's actually a different bill. That's Ms. Russell, you're referring to House Bill 2537, and that's actually a different bill. But looking at 2059, I don't see that they specifically say 8th grade. I only see that they're deleting that high school or its equivalent requirement, which in effect could allow somebody to move forward.
You could be, so it's saying you could be a cosmetology or barber instructor without a high school or equivalent.
That's our understanding of the pending bill.
I have a question. So, if we have our concerns, we can contact the representatives for this. What about the public or people that are now in school or even our clients, they could contact the representatives as well expressing concern? Okay.
Part of the legislative process, yes.
Okay. Thank you.
You're welcome.
There's also the regulatory requirements regarding schools that the feds, Department of Education, I should say, and national accrediting agencies require that students be high school graduates before they enroll. So that creates a conflict with those, something that, again, unintended consequences. So it sets up a conflict that a school might not be able to enroll a student who wants to come because of that. School policy, that is a requirement for us. So that cuts out opportunities for business growth on that end.
It's just like the apprenticeship. You know, they don't recognize it with NACAS or stuff, and so it cuts out that for the schools. But because like in the nail program, you'd have tons of people that want to do the apprenticeship, but we can't offer it like that because NACAS don't approve it.
I think these
So
are
it's
just
just a
concerns that we have and things
circle.
that, as the legislative process goes forward, that you know, certainly that needs to be considered. I don't think anybody would ever contend that someone who's completed the 8th grade ought to be able to go and practice law tomorrow. I don't think that would be accepted, or practice medicine or anything else. It's, you know, are we going forward with education, or are we pulling back from education?
Or just to teach
real
anything.
estate.
To be a
Any-
teacher, to be an instructor. I'm a teacher. And to be a teacher of something, I'm thinking at a minimum you need a high school degree or the high set, or, you know.
The 8th grader run for this Senate seat right here, you know. See how that goes, you know.
Oh, I taught 8th grade.
Yeah. It's a lot of
Let's get back
concerns.
on. Let's get back on
It's a lot
topic,
of
guys.
concerns.
You're asking about 2059.
Yes, ma'am. We're in the process.
In the House, it says it's been referred to the Calendar and Rules Committee, and in the Senate, it has passed on second consideration. That was as of February 5th, though. That's the last update. And it's been referred to the Senate Commerce and Labor Committee. So it hasn't moved in the Senate in a little bit. And in the House, it's on the Calendar and Rules Committee.
Maybe we're just seeing the effects of this industry being one of the, low-hanging fruits for the whole deregulation of everything. And so they can go after.
That perception is tainted because, when you look at the numbers of the licensees that we represent, we have one of the largest regulatory departments in this state. We have 60,000 plus licensees.
Licensees are at about 55,000, but when you add the businesses, we're at 68,000 between shops and schools.
There are
roughly
very, very few industries, businesses, regulatory boards in this state that you could even compare to the size. So we're low-hanging fruit because no one puts forth any initiative or action to protect their job or to protect what they actually seek and desire. So if 68,000 people would write to their senator, their representative, which are very easily posted. If you have an 8th grade education, you can look at it on the web and figure out who to write a letter to. And the only reason why there is a perception that we're low-hanging fruit is because there's not an initiative in this industry. So if the state of Tennessee, if you hold a license and this is important to you to protect your job, stand up, write a letter, go to the Hill. It's your license, it's your job.
If I could, because we've got a lot of pages to look at, I think as a board, what you all are all of us here do is protect the public, right? That is what we actually do.
Right.
So as you review the bills and read them in greater length, as Sherelle said, they don't all line up with each other. So obviously everything is still subject to change. I think, Ms. Sappenfield, you mentioned reciprocity. Every state is seeing changes. proposals, things of the nature, whether more or less than it's just one of those things, and they're looking to not impede not put barriers in people working. And so with that, keep those things in mind. With reciprocity, most states look at it like we do. Do they substantially meet those requirements? Number of hours, exams, work experience. And so when we wrote the rules, and you all worked so hard on those for apprenticeship, I think you took all that in account, and none of our reciprocal applicants have been held back that I'm aware of, because I do those certifications every day, because they're still doing 1,500 hours, they're still taking the exams, and they're passing. And so the combination licenses, that was one of the first things that Cheryl touched on, is still at that 1,500 hours. It's moving sort of in that direction, and then we have different amendments. So when it comes to students moving in or out of Tennessee, I think every state looks at that. Is it still substantially meeting? If that helps any with reciprocity.
As we get ready to move on to the next topic, I would like to close at least with my opinion on something. I think it's important that maybe I say this. The original legislation that was proposed that sort of merges the laws and cleans everything up and makes everything come into line, I have to say that I support that very much. I think that is probably a good thing. I believe that is going to lead to greater opportunity and job growth among the members of our profession, and it's going to be a good thing for the public because it gets more people out there in the workforce, and also taking care of the public in a educated and professional manner. The exception that I'm trying to make here today with the comments I made was really about some of the amendments that don't seem to make sense and seem to lead to maybe unintended consequences. I just want to be clear about that. Okay, we're ready to move on.
Thank you. Okay, so we are moving past that. Anything else? No?
No, there's nothing else. Let me know. Feel free to let me know if you have any questions individually later on in the process. If not, I will definitely update you all either way at the next meeting.
Thank you, Sherelle.
Thank you. We are on page 62 on your iPads, and this is regarding a new specialty school. The Black Pearl Nail Academy, LLC, is a new specialty manicuring school. Ms. Deruya Caldwell is appearing before you. If you give me a minute, I'll make sure that she comes up to answer any questions, and you've got all her documents there.
Good morning, Ms. Caldwell. Welcome. Thank you for being here. And as we take a moment to look through your paperwork in front of us, could you tell us a little bit about your school?
Absolutely. The Black Pearl Nail Academy is something that I have really been working on for a while. Actually, classes. Been a manicurist licensed for over 16 years, doing it, of course, before then. The school is actually a facility that I actually found. Like I said, I approved it. I was in a very bad car accident, so I couldn't facilitate that. The problem was the facility where I was going to do the classes, and in the process of healing and rehab, I found a building. So in the So the Black Pearl Nail Academy has come from that. I'm only taking 5. I want it to be a very close-knit situation where the students can actually get what they need. A lot of people don't know that nails now is an $8.7 billion industry. Nothing to be laughed at. We do fall kind of low-hanging fruit. However, I want to make sure that my students get everything they need where this is concerned. I think in Memphis it'll be the first full service where it's apprenticeship and not, so that they'll also have that option if they want to do apprenticeship, and they do. And I also have responsibility, not responsibility, but I also have a rapport with 5 different salons, well, nail salons, they're not beauty salons, nail salons that have cosmetologists or nail techs in them that have 5+ years of service license. So they'll be able to assist me with the apprenticeship side of it. Not choose apprenticeship, then they'll be able to stay at the school, at the facility. And I have one other instructor that is working with me, and she has been a licensed instructor for like 12 years.
You're a licensed instructor as well.
Ms. Caldwell, what is the total square footage? Do you know?
I want to say it's 1,400.
Okay.
thought
I
it
just
was
wanted
on
to at
the-
least have an idea. Thank you.
Your building have an upstairs to it? Is that what I'm seeing in the
Does.
diagram? Okay.
Office for the director and the assistant are upstairs.
So you have 1,400 square feet? Okay. Do the same number of, I know she said you're going to have 5 students. Do the same student-to-teacher ratios apply in nails as in the other programs?
It is. All specialty schools, per the rules that we wrote, had 5. And we have, as you can see, the business license information, her curriculum, blank contract agreement. We received also the 5 tentative contracts already. So as far as everything came into the office timely, and we've looked over everything. So some schools can choose to have more once they take off, but the minimum to get us started. And because the school would be doing the apprenticeship as well as the full contract, we would need a board member probably to inspect as well.
Caldwell, I have to say, I went to your Facebook page, and I really enjoyed your videos. I was like, thinking I wanted to sign up by the time I got through looking at it all. It was, I was very impressed.
Thank you.
Well, everything looks in order to me. I make a motion to approve.
Second.
We have a motion and a second to approve your school. All in favor, say aye.
Aye.
Opposed, say no. Motion carries. Ms. Caldwell, congratulations. You have a nail school.
Yay!
Thank you. Okay, thank you. Next, you have on your iPads, this is a, okay, thank you, reinstatement of a license. I'll let you review it, but just for the record, Ms. Pamela Spicer will take over this. This is regarding Mr. Donald Duckworth. He is going to be appearing before you regarding his personal license number 9552. That license was suspended on November the 6th of 2017. He has completed the agreement that he had done to take an outpatient course, and so Ms. Spicer will assist him and see if you've got any additional questions. Thank you.
Good morning, everyone.
Good morning.
Mr. Duckworth is present before the board today. I'll allow him to stand in just a minute and speak to you directly. The facts, as stated, were correct. You all suspended both the barber shop and the individual license of Mr. Duckworth in an order entered November 17th, 2017. At that time, you found there was a public health, safety, and welfare risk. I will allow you to review the summary of suspension if necessary, but generally the concern was over drug use. Both by Mr. Duckworth and allegations of drugs being sold in the shop, which were investigated by the Jackson Police Department, and this matter originally came to our attention from the Jackson Police Department. At the time of the hearing on the summary suspension, the initial hearing, Mr. Duckworth did participate via phone. At that time, the board recommended that he seek counseling. He agreed to that. He has completed the program, and you have a copy of his certificate. So he has reached out to me and asked to be heard today. He will be asking for both the board to consider not only his individual license, but the shop license as far as reinstatement. And I'll turn it over to him for you all to ask him any questions that you have, unless you have questions for me about what the history has been.
Thank you. Mr. Duckworth, first of all, thank you for coming down today and appearing before the board. We do like to see folks whenever they have something to say as serious as this. At this point in time, can you tell us exactly what it is that you would like for us to do, approve, disapprove today? What are you looking for today?
Yes, I would like for y'all to
or can you speak up just a little bit?
I would like for y'all to give me both of my license backs because I've been doing the right thing.
We have some questions from the board members. Ms. Patty?
Yeah, is this the first time this has happened? With
Ma'am?
Is this the first time you've been in trouble with the drugs in the shop?
Yes, ma'am. It's the first time. Yes, ma'am.
Mr. Duckworth, and I'm not exactly sure of your question, are you asking if this is the first time he's been in trouble with the board in connection to this, or had issues
before
with criminal
Yeah.
convictions?
The history is what I was wanting to know more of.
The history with this board?
No, with
his personal.
Personal?
Uh-huh.
No, ma'am.
I want to make sure you understand the question. She's asking, have you had any problems or legal issues with drugs in your shop or in your personal life outside of this particular hearing?
No, sir. No,
You've never been charged or convicted or arrested for anything like that before?
Yes, I have. Yes, sir. I have.
That's what she's trying to
Okay,
get to.
yes, sir.
Okay. More than once?
Yeah, twice.
Okay. Twice before this?
No, sir, twice. No,
Including
twice.
this?
Yes.
This event? Okay. Yes, ma'am.
Do you have a license or operate a business in another state?
No, ma'am. I mean, I was thinking about going to another state, but no, ma'am, I don't have now.
So you have no business in North Mississippi at all?
No, ma'am. I didn't ever go down there.
Okay.
My only concern, I'm glad, what kind of counseling or treatment or rehab did you just complete? Can you?
It was drugs and alcohol, which I wasn't no alcoholic, but I went for drugs.
Like a 30-day? Or
Yes, ma'am. It was 30 days.
that you got to be commended for doing that. That's great that you did that. I just my concern, and of course there's a concern here because we try to protect the public through this profession as a board, is that you get back out into the profession and the potentially the same clients you've always had, and if you had activities going on that were illegal through your work, what would stop you from continuing those with the same clients that you've always had if we put you back in the same place, you know, as a barber?
Yes, I was going to change my location and do something different. You know, for as my location, I was going to do something else.
Really strong.
Damn.
These are really strong charges that were brought before the board.
Yes, that's why I better myself.
Could you tell us about your time that you spent in your treatment?
Yes, it was just more of, taking a day at a time, staying away from drugs activities and, and having drug tests and a lot of, just
Was it inpatient or
outpatient.
Did you stay outpatient?
Yes, ma'am.
That's tough.
When you got in trouble in 2012 for drugs, were you required to go to a rehab at that time?
No, ma'am. I wasn't. I wasn't ready to do to better myself at that particular time. And now that I just said I need to do better.
Well, we would all agree with that, and hope that that's what happens.
Mr. Duckworth, just out of my curiosity, how long have you been a barber?
Since '93. Yes, sir.
So the board is aware, both the shop, my information is both the shop and the individual license has been in place since 1992.
Yes, ma'am.
Do we have the opportunity to approve one or the other, but not necessarily? It's not a package deal. Is what I'm asking.
Correct. The board could consider reinstatement of the individual license and leave the shop license suspended and decide to move forward with revocation of the shop license. Or leave a suspension in place on the shop license for a length of time.
Mr. Duckworth, how do you prepare for your continued recovery from here on out?
Like I said, staying away from, drugs, and just better myself. That's what I'm taking a day at a time.
Are you trying to attend any classes or meetings or anything?
I still do go to meetings, which I can complete my course, but I still, stay positive on meetings. I still go there and visit them and stuff like that.
You have a shop where you can, if your personal license were reinstated, do you have a shop where you could go and practice? If you,
I don't, but I will be looking. That's what I was going to do in the future.
Are you saying that you would like to be employed by someone else and not have your own barber shop?
I would like my own barbershop, but if I have to, I'd do something, I will.
Mr. Duckworth, have you been incarcerated for any of these charges? And
like I said, it wasn't selling, it mostly was using, you know what I mean? But a day or so, that's about all.
Do you face further incarceration in the future, or any of these things still pending legally from the criminal aspect of it?
No, sir.
Or has all that been resolved?
Yes, sir. Yes, sir.
Okay. You may have asked, but I may not have heard quite correctly. Did you indicate that you are still in a program of some kind?
I finished the course. I just still go there because it's a positive place. You know what I mean? It just keep me up. Keep me from all the junk.
How often do you go?
I go like once or twice a week.
Are those AA meetings?
Ma'am.
Are those AA meetings?
and drug counseling.
Okay.
Unfortunately, I'm very familiar with this kind of situation, and we can ask you what your intentions are, and you're going to say every time that you're trying to better yourself, of course, and that you want to be better. What we have to decide as a board is, do we think it's safe for the public that we give you back your personal license? I really feel like that you don't deserve a shop license. I don't think you are ready to run your own shop with your past history. And a predictor of future behavior, you can always look at your past behavior to kind of see that most people don't change. We would love to see you change, but I don't feel comfortable in allowing you to run a shop. I really don't. I would not vote for that. But to allow you to have a license to practice maybe in another shop so that you can have some income, because I'm sure you need an income.
Ma'am.
And we don't want you to resort to selling drugs for an income.
Right.
But there again, my concern at the very beginning of all this was, you know, the clientele that you have, was that your
Source.
source of the other income. So I don't know, just really a little bit torn right now. And I can be very skeptical about the whole rehab situation. I hope everybody that goes through it can come out on the other side clean, but it doesn't happen. So I don't know. That's just my opinion. And there's a lot of us up here on the board, and we'll have to vote on this. And
in my experience, Mr. Duckworth, I'm also a barbershop owner, and I'm really proud that many of my employees are in recovery themselves. It's something I take great pride in, providing a safe place for them to work that's alcohol and drug-free so that they can be successful in their recovery. And I guess I would ask that I, too, Nana, feel that I would like to see you be successful first as a person, and then as a business owner. And I would like to see us grant your personal license back so that you can get back to work. I'm skeptical of the shop license at this point. I'd like to encourage you to practice barbering and come back and reapply for your shop license once you have a few, I don't want to say years, I don't want to put a time limit on it, but once you've gotten yourself to a really good place, I would absolutely want to see you come back and encourage you to apply for a shop license again. I think that's very possible with the right guidance and the right structure.
Pamela, I have a question for you.
Sir.
If, and I agree, I think everybody on the board would like to see you succeed personally, but before you take on that extra pressure and risk of a shop to put you in a even more stressful situation, we want to make sure you've got your legs under you. If his license were to be reinstated, can that be done with some type of probationary situation or attachment to it, or not? The individual license.
The individual. I would say they could some parameters on it if the board chooses to put some parameters on it.
That would look like an agreed order of some type, or okay.
It would obviously have to be something that Mr. Duckworth agreed to and signed. Otherwise, we would have to go to a hearing.
Is there any legal precedence on this, that we've done this before? On an individual license?
To put someone on probation?
Yes, to...
Not that I'm aware of. That's why I'm giving the caveat that it would have to be something that Mr. Duckworth
completely
agreed
voluntarily
to and is agreeing to voluntarily. Otherwise, the only thing I could do is go forward with a hearing. So one option is to, as I think you all have already discussed, allow reinstatement of the individual license but not the shop license. But there again, on the shop license, it's been suspended, and the rules state that I need to proceed within a reasonable time with a hearing. So there again, as it relates to the shop license, I do think we would have to come up with some either agreed order, or there again, I would have to go forward with a hearing related to the shop. And from speaking to Mr. Duckworth, it would appear from my conversations with him, if the board considers allowing his individual license to be reinstated, we could work out an agreed order on the shop license with something in line of the shop license remains suspended for a length of time, and then he comes back before the board for you all to consider it. Legal would just need some end to this, whether it be by hearing or agreed order with Mr. Duckworth.
Did you make a recommendation on the time of suspension for the shop license?
Really be up to the board. I mean, it's sort of like the board has already said, to put some sort of time on it. I would not think we would want to go over a year. I would think we would want to do less than a year, but that's just food for thought, something to consider. I would not think we would want to have something pending for more than a year.
Let me ask you this. Is there a way to just revoke this shop license, and if Mr. Duckworth wants to have a shop again, he could apply for a new shop license?
Yes, that is your other option. You can reinstate the individual license or choose not to, but that's what I was saying. Either way, we have to have some finality to this. So it would either need to be an agreed order, something happens to the shop in the future, or you reinstate the individual license with or without caveats, and then the shop license, you're authorizing me to go forward with revocation or doing some sort of, he comes back before the board relating to the shop license in so many months.
I would be interested to know what your opinion would be in directing the board if that was. We're not lawyers. we're not social workers.
How about if something looked like this? And of course, Mr. Duckworth, what we're trying to do, just so that you'll understand, is we're trying to find a path that would allow us to assist you get your license back in order so that you can go to work and still meet our obligation to protect the public. What we're discussing here is in no way binding on you. We have options that we can either approve or deny. We can do that. And that is not meant to force you to take some choice or other. I'm just giving you information. What it might look like, and it would be completely voluntarily on your part so that we wouldn't need to take a different action, if perhaps the board said or offered you to reinstate your license with a caveat, in other words, with a provision that you would be kind of under probation for maybe a year, so that if you had any other charges or problems, then your license could come back in front of the board and hold your shop license out for that same year, so that within a year you could come back. Am I saying this well? I don't know if I'm being articulate or not. Okay.
Are these charges a felony?
Yes.
Are they felony
In the
charges?
past, the charges have been reduced to misdemeanors. I'm not going to speak to every charge because some of these were in the past, but Mr. Duckworth could speak to it if he likes, but some of the charges in the past have been reduced to misdemeanors.
Even when we have every meeting we have before us, people that want to test who have charges, and we just automatically require a signed agreed order with a 2-year probationary period, and I can't see this being any different for allowing you to have your, if we voted to reinstate your personal license, I think it would just make sense if we did what we do for the other ones who have charges and allow them to test, that we require you a signed agreed order and a probationary period of 2 years. Just saying that.
How do you feel about that?
I agree. I mean,
You really understand it? Because, I'm really proud to be on this board because, we've held a discussion open about your situation for at least 10 minutes, and I've been on other boards where these are just very serious charges against you. Do you understand what we're asking?
Yes, I understand.
Okay.
Now, I do want to make sure the board understands. To my knowledge, Mr. Duckworth does not have any pending charges currently. This was brought to our attention because of a raid by the Jackson Police Department. There are no current charges.
Do we need to vote on these separately, the shop license?
Yes, you need to vote separately, and we'll need a roll call vote on both the individual license and the shop license with a recommendation of what we're going to do about the shop license if you're not going to reinstate the shop license, and what we're going to do about the individual license if you are going to reinstate the individual license, if you're putting any caveats on that.
Mr. Duckworth, did you have any employees at your shop, or was it just you?
I had one, but I don't,
He's gone somewhere else?
Yes, ma'am.
So you had the furniture, and the shop is still there, it just hasn't been open. Is that correct?
That's correct.
And just so the board is aware, to my knowledge, there has been no one in the shop since the license has been suspended.
Okay. I recommend that we go ahead and reinstate his individual license, unrestricted, by the way. I think if we do that, that'd be fair to him, and I think he will be pleased with it, and I think the board, we all should be pleased with it, and we'll worry about the shop license later.
Is that a motion?
I make a motion to reinstate his license unrestricted.
So we have a motion that states that we would reinstate Mr. Duckworth's license with no restrictions, no attachments to it.
Let's only handle the individual license
Exactly.
first.
We're going to do the personal license first. Do we have any more discussion on that? I'm sorry, we have to have a second first. Do we have a second before we have further discussion?
I'll second that.
We have a motion and a second to reinstate the license without any caveats or attachments. Discussion?
I would just like to see some type of probation put on there for him, just to make sure he stays on the right path.
Well, but
for the public.
I mean, what
6
good
months
will
or a
that
year?
do?
If it's like the regular agreed orders that we do for someone who comes out of a jail sentence, they'd be on probation with their license for 2 years, and during that time period, if they had any other legal troubles or infractions, then their license would automatically be revoked.
So we wouldn't have to go through.
Is that suspended or revoked, Pamela? I'm sorry.
That's true, but again, Mr. Duckworth has to agree to that.
Yes, if
And he
agrees.
may not be willing to agree to that, and then we're basically going forward with a hearing.
We have a motion and a second on the floor. Is there any other discussion on Mr. Jimmy's motion?
Well, I mean, I guess as part of the complaint committee, if there were complaints against his personal license, we would have a history, right? Because we get that with every case that we get. And that would show up, correct?
Right.
So if there are infractions, we will see them and we will know that there is history, regardless of whether or not there's an agreed citation. Correct? And we'll go over one today where, previous no-nos are very clearly documented and are taken into consideration.
Any other discussion? We're going to have a roll call vote on this one, and Ms. Roxana?
Yes, absolutely. The motion as it stands by Mr. Boyd is to reinstate the license unrestricted. There's a second by Ms. Amy. And I will start with Ms. Kelly Barger.
Yes.
Mr. Jimmy Boyd.
Yes.
Ms. Anita Charlton.
Yes.
Ms. Nina Coppinger.
No.
Mr. Ron Gillihan.
I'll reserve in case of a tiebreaker.
Okay. Ms. Brenda Graham.
Yes.
Ms. Judy McAllister.
Yes.
Ms. Patricia Richmond.
No.
Becky Russell.
Yes.
Ms. Mona Sappenfield.
No.
Amy Tanksley.
Yes.
I have 7 yeses and 11 here today, so the yes.
Mr. Duckworth,
Sir.
your license will be reinstated with no, I'm sorry, with no attachments to it at this time.
And that's related to license number 9552, which is Donald Duckworth's individual license.
Individual personal license, yes.
Correct. Now we have the license of Master Cuts, which is license number 5831.
Make a motion to not reinstate and to close the shop until he reappears.
Second.
What was the length of time?
Is that a motion to revoke?
That would be what the proper motion would be, to allow the summary suspension to remain in place, if that is your motion, to allow the summary suspension related to the shop to remain in place, and the board is voting today to revoke the shop license. And then it would remain suspended until I can go forward with a hearing on the revocation in front of an administrative law judge.
Close it down.
It would remain suspended
Okay.
until such time, yes. And then the shop license would be revoked. That's what I have authority to do.
So we have a motion to maintain the summary suspension and seek revocation. Is
That's
that-
my understanding of
Okay.
Ms. Richmond's motion.
Do we have a second?
Second.
Do we have any discussion? We'll have a roll call vote.
Thank you. Ms. Kelly Barger?
Yes.
Mr. Jimmy Boyd?
Yes.
Ms. Anita Charlton?
Yes.
Ms. Nina Coppinger?
Yes.
Mr. Ron Gillihan? Ms. Brenda Graham?
Yes.
Ms. Judy McAllister?
Yes.
Ms. Patricia Richmond?
Yes.
Ms. Becky Russell? Yes. Ms. Mona Sappenfield?
Yes.
And Ms. Amy Tansley?
Yes.
All in agreement.
Motion carries. Okay. Mr. Duckworth, your personal barber license has been reinstated. Your shop license has not. And you'll need to proceed however the attorneys and you folks normally proceed in those matters.
I will step out in the hall and speak to Mr. Duckworth about this.
Good luck to you. We hope we don't have to see you here, but you're always welcome. Okay. We're finished.
Good luck, sir. Thank you. Let me know if anyone needs a break. We are otherwise on to our applications to test. This starts on your iPads on page 84. Applications for examination, we have only one in this category. This is for Mr. John Brian Swafford. The applicant has a felony within the last 3 years and is currently incarcerated. The request is for him to be allowed to take the examinations, the required information disclosure from the individual, and recommendation letter from the facility have been provided. With master barbers, per statute, they may be denied if the applicant or the individual received the felony while working in the industry. In the past, this board has always provided the 2-year agreed orders for a probationary period. I will let you look at his documents, and then we would need a motion.
We motioning him to test, or we motioning him for the license?
It would be to test. PSI can go into the facilities and give them the exam.
I make a motion we approve him to test with the 2-year signed agreement.
Second.
We have a motion and a second to approve for testing with the 2-year agreed order. Any discussion? I'm sorry, we have a second, yes. Any discussion? All in favor, say aye.
Aye.
Motion carries.
Thank you. Next, you have an applicant requesting their hours. This request is for cosmetology hours to be able to test on behalf of Mr. Colton Brewer. He has presented an affidavit stating that he attended Plaza Beauty School in 2014. The document on page 90 is the proof of hours completed through November of 2014, and that would be a total of 1,478 hours, 0.5. The school closed shortly after he obtained that number of hours, and so he is short 21.5 hours, has provided the notarized document, and is requesting the board waive the 21.5 pending hours he would need.
That school did close.
Yes,
And
in
that's-
2014.
So question, because there are several others on these lists here, we're awfully close to that. Has anyone else come forward?
For the last 2 years, we've probably been dealing with most of these students. So,
Okay.
yes, some have not. Some went on. If the board recalls, this school merged with a different school, changed names and so forth. So we've had a little bit of everything. We haven't had any in the last year and a half, I think.
Oh,
So
okay.
we actually went through most of it early on.
So we would assume that those that wanted to move forward or be resolved have
Hopefully
come forward.
Correct.
Okay.
Thank you.
Thank you.
You are welcome.
And we would waive his hours and then allow him to test?
Yes, and I mean, otherwise, if you think he needs the 21.5, the issue is finding a school that would give him that small amount in order to pass the exams. If he's been out of school since November 2014, it's likely he may choose still to get a refresher course, prepare for the exams. But if they're waived, then he would complete an application test and the board would submit him to PSI.
Make a motion for him to go ahead and test.
Second.
We have a motion and a second to approve the test. Any discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. Next, you have an application to test as an esthetician with hours from Brazil for Tatiana Pereira Carter. Ms. Carter provided translated notarized certificate and a diploma showing that she completed 1,200 hours and that they were completed in 2005.
This is for an esthetician's license?
It is, which is 750 hours in Tennessee.
Oh, did she work as an esthetician there?
In Brazil? Yes. And in some cases, we get pictures and documents. I just don't provide all of that. Generally speaking, we try to keep it to the certificates, things that are translated, and a view on page 95 of kind of the hours that she did.
My concern was that it had been over 7 years if it were only education and no work experience.
It's rare that our international applicants don't have work experience. It's just we obviously wouldn't be able to vet it, but they will provide a kind of a written statement sometimes or pictures.
Does she have a Kentucky license?
No.
Okay.
No, she's coming straight from Brazil, to my knowledge.
What am I looking at? This says her address is Scottsville, Kentucky.
Scottsville, Kentucky is about 2 minutes down the road from Lafayette, Macon County.
Okay.
It's right on the state line.
Okay.
And she may be applying at the same time with Kentucky. I'm not aware, but she does not have a license right now.
I would actually state that the Brazilian, on an international standard, of a higher compliance than what the state of Tennessee would be in school, things that they actually are able to perform. I think she'd certainly be qualified. I would make an motion to have her test.
Second.
We have a motion and a second to have this applicant take the Tennessee test. Is that both parts? Okay. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Next, you have an application to test as a manicurist with hours from Vietnam for Thuyen Thien Mong. Ms. Nom has provided education as far as the diploma and transcript that needed to be evaluated. She had 714 hours completed at World Nail School, and the document provided is the Aqua International evaluation certificate that she completed. So at this time, she's requesting permission to test.
Motion that we approve her to test?
Second.
We have a motion and a second to approve for the Tennessee tests. All in favor say aye.
Aye.
Motion carries.
Application to test as a cosmetologist with hours from Ecuador for Maritza Gabriela Vaca. Ms. Vaca has provided a translated transcript showing 2,816 hours completed in the year 2000.
I make a motion to have her test.
Second.
We have a motion and a second to have this applicant take the Tennessee test. All in favor say aye.
Aye.
Oh, we have a question?
I thought you would ask for
I'm sorry.
discussion.
Pardon me.
I'm just curious about the looks like this is addressed to the State Board of New Jersey. Does that throw up any red flags? On page 102.
I think the translating services are from New Jersey.
Okay.
And so they might have very well, let me look, translate. Where did I see New Jersey?
Making sure she's applying to be in the right state.
Is she just throwing them out there and seeing
Yeah,
which
if you look at the top, the address for the translation
Whatever
company
state.
is
Okay.
New Jersey. I think they just
Got it.
assume that that's where
Jersey's
it
enough
was
place.
from. And she may be applying
yes.
too. There's
Have any other questions? All opposed, say no. Motion carries.
Our last applicant to test is requesting to be allowed to test as a cosmetologist with hours from Vietnam for Phuong Thai Thu Nguyen. Ms. Nguyen provided the notarized transcript showing 1,760 hours that were completed in 1998. That document is notarized, so it did not go for evaluation.
Motion for her to test.
Second.
We have a motion and a second for this applicant to take the Tennessee tests. Any discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. We will start with our reciprocity next, and we have an applicant here that flew in to be able to speak before the board. First on your iPads is an application for reciprocity of a cosmetology and a barber instructor license from Missouri. This is for Ms. Deanna Coleman, and if you give me a minute, I'll make sure that she's at the mic so you've got both applications there in front of you. Fill them in on everything. You just need to make sure that's red. Cell phone.
Good morning.
Morning.
Hi there.
Thank you for being here today.
You have before you, bless you, Ms. Coleman, also Mr. Kevin Johnson with Paul Mitchell the School in Knoxville is here appearing before the board to answer any questions and explain her experience. Ms. Coleman obtained her cosmetology hours in Knoxville, so the 1,500 hours. I think you've got that toward the end of her document. She actually had a license here in Tennessee between 2012 and 2014. The certification from Missouri shows both disciplines, barbering and cosmetology, and the date that it does reflect says 2018. I just believe when they do an upgrade in that state, it looks like each year they just give a brand new year. So it's a little bit different than what we do. So I wanted to kind of answer that. They also have a crossover of licenses. Again, every state looks at those kind of things the best that they can. Their crossover is 50 hours. So it
50? 50?
50, yes. Between barbering and cosmetology. And of course, as we all know, there's not a huge difference. So therefore, that's also in line there. And as far as the instructor piece that I did want to explain, Ms. Coleman was wonderful, had her exams that she was able to provide. So she has tested as an instructor. And let me get those two. So on page 112 and 113, you will see her passing score in the theory and the 96 of her practical, and those are for her instructor hours. And so I will let you ask any questions that you need. She's got a job opportunity that starts tomorrow. This board approved the Paul Mitchell School, no pressure, to open tomorrow, and they are in need of barber instructors. There's a limited pool, as those of you that are in schools know, as far as number of instructors in cosmetology and barbering is a lot lower. And so they are appearing, hoping to be able to take off with their program tomorrow. So I will turn it over to you.
On page 113, the overall status was incomplete, but because she's provided
Correct.
evidence, we're
She
good.
still had one pending, so I
Okay.
asked the same questions.
Okay.
It looks like that's the case, yes.
Mm-hmm.
So why did she need to come before us?
In Tennessee, you need at least 300 hours for instructor, and she does not have hours. So in Missouri, she does not need, she can use her work experience hours to be allowed and approved to take the exams. That's different from ours. So I would not have been able to approve her because that minimum requirement is not there. It also doesn't state a minimum number of hours that you need to work, but Missouri is not the only state that allows work experience in shops to cross over to instructors. But of course, we've got the 300 hours.
Gotcha. But she did take
Take 'em and
Exams.
pass both exams. And now, the exams say, the exams say instructor cosmetology practical, cosmetology theory. The licenses themselves are on page 115 and 116. And so when you look toward on page 115, I think it is, give me a minute. Yeah, 115, crossover instructor. It doesn't say cosmetology instructor or barber instructor, but it clearly
It's the
with
same.
the 50 hours appears, and she can correct me, that in Missouri she's allowed to teach both disciplines. So this board can look at approving both. They're desperately in need of her master barber license for tomorrow. Master barber instructor, sorry.
We're just making a motion to approve her license.
Yes, and I would need guidance if the board is comfortable with both. She would be getting a master barber instructor license and a cosmetology instructor license. She's actually completed an application for both.
I think I would be in favor of approval on this. I don't see a problem with it, since she
And she's
does
already
have the crossover time.
She's already had a test and done really well. You did
I would make
well
a
on
motion
both
that
tests.
she could start work tomorrow, that we would approve it.
I second.
We have a motion and a second to approve reciprocity. All in favor say aye.
Aye.
Motion carries.
Frank wasn't even here to help.
That was easy.
She was coming to start work, but I said, I don't know that you have to fly in just for this. And that's when the date came up. So it's very nice to have her.
And Frank missed it. Where's Frank?
Yes.
Come on, man.
Yes, he did. He did. I think in her work experience, she's actually worked in one of his shops. And so he'll be happy to hear that.
Where's Frank?
Okay, we are on page 132. This is an application for reciprocity of a cosmetology license from Oregon for Laura Bus. The certification shows an initial licensure in September of 2009 with 1,700 hours by examination. This license on page 135 is for a hair design license, a little bit different than ours. Below it, she has a cosmetology independent contractor. And so she's provided tax records between 2012 and 2016 for having worked in Oregon during this time. My recommendations that we approve her for reciprocity.
Make a motion that we approve her for reciprocity.
Second.
We have a motion and a second to approve for reciprocity. Any discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. Next, we have an application for reciprocity of a cosmetology license from Florida for Luis Stanley DeCar. The certification shows an initial licensure in May of 2005 with 1,500 hours and no practical exam. The certification on page 142 is the one that shows that initial date of 2005, and then as we've discussed several times, Florida, it appears if you don't renew at any point, even when they reinstate the license, the date changes. But this individual has been able to provide a letter from an employer that states that she was a barber / cosmetologist from June 2002 to 2010. Again, many states allow both practices to be done equally. Mr. Carr has also provided an explanation of why she left the industry, and that's on page 144 in 2012. And so she has not been working since 2012 in our industry, and now she has a job opportunity. My recommendation would be that she take the practical exam.
I make a motion that we go with the recommendation that she take the practical exam.
Second.
We have a motion and a second that we takes the practical exam. I have a question before we vote. On page 142, it says her current license status is null and void. So
Go to the previous one. If you look on page 141.
Okay,
Yeah.
I see the date. Okay,
And so that's,
good.
we had received the current one, and of course, with no work experience from 2017, there was really nothing for me to even present. That's when she got the original one. I just think she had a gap between there, and like she said, she actually moved and left the industry. However, they were able to let her renew.
We have a motion and a second. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank An application for reciprocity of a cosmetology license from New York for Wendy Fancher. The certification shows an initial licensure of February 2017 with 1,000 hours, and it reflects the passage of both exams in 2001. That certification's on page 149. New York certifications always indicate that prior records have been destroyed. I don't think they keep anything for longer than 5 years, so that's the case with her February 27th licensure. So she very likely might have had a license between 2005 and all the way to 2012. Anything prior to that would have been destroyed. She's provided a letter explaining her work experience. Many letters from clients also came in. I did not copy all of them. I think you've got a couple on your iPads, as well as certifications regarding additional education that she's taken, and then some tax records, but they are between 2005 and 2009. Given that she's practiced off and on all of these years, my recommendation is to approve her for reciprocity.
I'll make the motion to approve her for reciprocity.
Second.
We have a motion and a second to approve for reciprocity. Is there any discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. And our last reciprocity applicant is a manicure license from Texas. This is for Ms. Tuyet Nguyen. The certification shows an initial license was issued in February of 2011, and that certification is on page 164 with 603 hours and both exams. Ms. Nguyen attended one of the 9 schools in Texas that the board requested an investigation be conducted on in 2014. The conclusion of that investigation resulted in many revoked licenses in Tennessee, and the board decided at that time that we would not be accepting hours past or in the future from any of these schools. The investigation determined that individuals that received hours were in fact not living in Texas at the time of their hours. It covered files, and they audited students between 2012 and 2015. Ms. Nguyen has provided many documents to support that she has lived in Texas since 2009. She's provided records that show owning a business, paying taxes, as well as owning a home. She is waiting on this decision in order to move to Tennessee, so she is actually still living in Texas. The time frame of the hours that she completed, and you can see her certification on page 169 from the school, does not fall in line with the audit that was conducted as part of this investigation. And so I felt from speaking to her and hearing her passion on the fact that she did attend school, her document she was able to approve, that Texas driver's license shows it was issued in 2009. Again, none of those records were obtained from the other individuals that we had to proceed with. And so for the first time, we're kind of readdressing one of the applicants from these schools, if we accept the hours or not. So that is her request. If we accept the hours because it's clear that she at least was a Texas resident, was in the business, still is. This is her active license as Texas is what she's using. Then based on those parameters, I don't know if we can look at future applicants differently or how the board wants to proceed. We can start by deciding with her.
What is your recommendation?
I'm given everything here, and sometimes I withdraw my recommendation when I've spoken in length. She received a letter from me that says you attended one of the schools that we've audited, and the board has decided to not accept these hours, therefore we cannot grant reciprocity. And that's the letter we've been sending out since the beginning of 2015, I think. The board remembers we held back reciprocity for about a year and a half from all Texas while we kind of had this resolved. And so she received my letter and, of course, called me, and from the beginning it was, I lived here. My kids have gone to school here. This is. I'm still here. I'm still in Texas and want to move to Tennessee, but can't. And I attended school, so I asked for any document she had. That's her transcript that says she attended in 2010. I don't think anyone else has provided this. That's not to say that they couldn't have, but as we debated on the hours, It was very clear, especially on the complaint cases and the revocations, that those individuals were living in Tennessee getting hours in Texas, which is not possible to do. This is the first student that really has different time frame and has very much pushed the I did everything right. So based on that, I would say she meets the requirements and she's provided some proof.
I would point out something on the bottom of page 169. Maybe it'll help, and it's possible that I'm misreading this, but I've seen these type of documents before. If you look at the very bottom of the page, BNCI, CUR, that would, at least in the context that I'm used to seeing that, it's the name of the school or the initials of the school, and that student was current at the school of 12/18 of 2007. So she was at least there at that point in time. That's what that indicates to me. I've seen those before. So
I have a question. Is there any way to know, like, from the investigation that was done in Texas, if the ownership of some of those schools changed hands, like from one point on? Say if, she went to school before in 2010, and then the ownership changed hands, and that's who was giving out hours or selling hours or whatever. Is there any way to?
We could. We definitely could. We've not gone down that path. Actually, not even on the ones we ended up revoking, because it was pretty clear there was just they were never in Texas.
But that could be the case.
We could. Oh yes, and her hours, everything from the documents to her statement, is different. It's not the time frame they audited, so it could be. Now, the majority of these 9 schools, if not all, were not revoked. They had a civil penalty, but they, anyone that gets my letter says, but the school's open today. I called, they didn't know about this. But the board, has this limited, we've decided to not accept these because of these concerns.
I feel all her documentation she's provided that I would approve.
Has she taken both tests?
Yes.
Okay.
Yes.
And with her taking the test here?
She's
already tested.
She's
already
tested in
tested.
Texas.
Okay.
So Texas definitely, and like us, they're facing different hours now and different bills. But at this moment, they've got the same number of hours. She definitely finished the 600 hours for manicure. She did both exams. I think the question with that investigation was the hours, which is the basis for everything. So we've been denying them.
I give her reciprocity.
Okay.
So it's a motion to approve reciprocity. Do we have a second?
Second.
We have a motion and a second. Ms. Judy, any other discussion? All in favor say aye.
Aye.
Motion carries.
So my question, since this is the first one like this that we're looking at, is, and when I have the conversations, because like I said, they received my letter and are very upset. And so we talk about the whole thing, the attendance of school, exams, the practical hours, and generally it's always stopped there. But if an individual, the time frame is either way after the issue or way before, if the board is comfortable with us asking for additional documents, I'll be presenting them to review. This is the first time. Good?
Very thorough.
Good. Okay. Thank you. Are we good to proceed? I don't think we have too much more. Does the board need a break? No?
Go.
Let's go. Okay. We are on miscellaneous items, and the first one on your iPads is a request for consideration of a lapse license. This is for Mr. Lakeith Ontavio Briggins. Mr. Briggins was supposed to have renewed his Master Barber license by January 31st of 2017. And after that, after January 31st, 2018, the statute requires that he would have to test in order to reinstate. He has provided a letter explaining, and his letter is on page
186.
Yes, thank you. Explaining that he was told how much he owed and that's what he sent at the time. The penalties for master barbers, as most of you remember, go through a doubling period. They back when he was paying it, 80 became 160, became 240, became 360. And so at no time would he have owed the 242, but he says that that's what he was told, and he submitted it. The issue is very likely one of timing, because if you let one more year go by the date, the additional amount would be added. And so by the time he contacted the board, he owed an additional $118. That should have gotten here by January 31st, 2018. He did everything by mail. Had he been able to do this via the internet, we wouldn't be having the conversation because it would have gotten here. The envelope got to the building on February the 1st, 2018. A lot of times we can waive some of these things. It is one of the forever stamps that doesn't tell us when he physically put it in the mail. So at your discretion, even though the statute says he must test, I think we have some evidence that he really did mean to send the additional amount. It missed it here by a day. So I will leave it to your discretion. Now, I said 1 day. There's 3 years that lapsed in there. I understand that. But
He sent the correct amount of money.
he did. We have the correct
You have the
amount
right
of money.
amount of money. Mail from Memphis be delayed by a day.
Oh.
All those fees and rules have now been changed, have they not?
The basic fee for our barbers are just like the cosmetology. Everyone is $60. But having said that, a portion of the law still says double, and so the $60 becomes $120 still. Hopefully, as we clean up things and things progress, we can get it out of there, and then it'd be limited. So $120 isn't great. It's better than $160. But that's the piece that gets confusing, is the doubling.
That's right. 3 years later. Rules on fees hopefully will be cleaned up.
So the rules are, it's the law, right?
Oh,
That's
it's the
the
law,
piece,
sorry.
yeah,
Sorry.
unfortunately.
The law.
But and he sent the 242. He just sent it right at that January flip again. So that's where the additional fee was charged. So it's very possible that he thought he was caught up when he sent the 242 and didn't realize he'd waited long enough that it rolled to that last year he had.
What is the will of the board?
I don't think that's the wrong way, but it sounds confusing to us, which I would imagine only makes it more confusing for the licensees. So I don't think he needs to take both exams again, unless you think that it's absolutely necessary.
And so to clarify, the statute says to be reinstated, you must take the exams. The reinstatement exam is, the theory is just on the rules and laws, and the practical is the whole thing. The question I guess I pose is that this didn't get here obviously timely, and we met January 29th, so it missed us because it was in the mail. Had he done it online, because by the end of January he knew what he needed to do, the check had probably been cut and left, but because of the mail, it got here 1 day late or one morning late.
We don't know the postage stamp
We don't,
date,
because
but
of the forever stamp. We run into that all the time. Having said that, I can say nothing from Memphis gets here in a day if it's put in the mail. That's just not. It's taking every bit of 10 days generally, which is amazing to me. But
I think his intent was there, and
yes,
wasn't
yes.
trying to trick
So
everybody.
that is one correct, and I ran that by legal counsel. So Sherelle and I talked about it. If we look at that intent and the February 1st date, and can anything be done, because it wouldn't have missed it had he been able to do it online.
Ed.
And I think part of the concern is, whether or not there was a miscommunication. We weren't able to find the recording, and so just in all fairness, in the event that there was, we wouldn't want somebody penalized unfairly. And so we just, wanted to make sure that the board understood that there's a possibility that the individual may have sent the whole amount, but we're not sure whether or not there was a miscommunication. So in all fairness, with it being this close, we thought we'd present it to the board for your consideration.
I would be willing to make a motion that he could test. I mean, we don't have power to extend a month or that, a year.
But right now,
but-
he has to test. No motion needed. What he's asking is that he not have to test so he can start working again. And I agree with what Cheryl, she added, and it's the fact that his statement on his letter says that he spoke to a representative from the board and was told he owed the $242. And that's, I don't know where the extra $2 comes in. That could have been a but depending on how quickly you mail it, that $240 could have been accurate. And then February 1st, it was no longer $240, it was $360. So, and I don't know that we would have walked him through that additional, by the way, your check from Memphis needs to get here by January 31st because if the mail is delayed, it's an extra amount.
Amy, what do you think? You're pretty good on splitting these hairs.
There's no way we can avoid a test or minimize the testing. That statute.
The reinstatement test says must reinstate or must take the practical, and then the reinstatement test, we've made it be the rules and laws. I think the statute says must take the laws and the practical, and so that's where we come in with the 25 questions for the rules and laws and the full practical.
I'm just laughing, forgive me, because the rules and laws are changing all the time. With several we already went through are possibly changing as well.
I'm still confused, so forget.
And on occasions, and it's been rare, we might have had, and Mr. Gillihan, you might remember, we might have had another, I think it was someone incarcerated, that it was obvious the intent was there to mail us the fees, but because
Incarceration, he wasn't able to
get it to us.
There was a father
Yes.
taking care of
Yes.
his son's paperwork.
Yes, and so
I do remember
that's
that.
what we considered. It was an unusual situation where the individual incarcerated thought it was done, the father had mailed it, didn't know the amounts, and there was no continual, communication back and forth, and the board took into account all of that package. So here, part of it is missing it by one day. The other part is possibly misunderstanding and talking to the office and thinking that's all he owed and he was done.
And I
What
will
time
say,
it was, right?
I'm sorry.
Wait,
I didn't
sure.
want to interrupt.
No. Excuse me.
I found this statute. It's 62.3.129C, and it says a certificate of registration for a master barber that has been expired for more than 1 year but less than 3 years may be reinstated upon payment of twice the fees that would have been collected for the timely and continuous renewal. Have to go to the fees to actually figure out what that is. I would say my view on it, because the statute says upon payment, is that this could be interpreted either way, either when he mailed it or when it was received. With contract law, there's something called the mailbox rule, and it essentially says once an individual has mailed their acceptance of an offer, then that is a valid contract regardless of when it's received. And I will throw out the reality that mail can sometimes be delayed. So if somebody sends something, and I'm not saying that this particular rule applies, but I'm just showing you an analogy of how the law operates in similar situations. If somebody mailed something out before a deadline and the mail, for whatever reason, was delayed by weeks, I don't think it would be fair, unless the law absolutely required it, to penalize that person for something that they didn't have control over. And I think there's room here for this individual a little bit of leniency if it so wishes, just because it's clear that it was sent before the expiration date. It was received after, and it looks like that particular fact was outside of the individual's control. But, I do acknowledge that we are talking 3 years here, too, and that's that's within your discretion. I just want you to know there's some discretion. The law doesn't say upon receipt of the payment. It says upon payment, and so that gives you all some discretion on how to construe that. I don't think we've had this exact issue come up, and so there is some discretion right now on how how you might wish to proceed. And I think that was one of your questions.
You know what the data that was on the check?
No, we don't. We don't, at least my office does not retain the front and back. It goes through fiscal pieces of the check. And the only reason we didn't pull it is because generally when we speak to licensees, the data that they wrote on the check is irrelevant. We've had checks sit for 2 months, and we knew based on the envelope that it didn't take 2 months to get here. So generally speaking, that date. But obviously, there's no way it left Memphis with a forever stamp and got in the same day, from the 31st to the 1st.
Well, we could take into consideration that when we voted to give leniency to the inmate, he got it out of the jail and he thought it was done, and this individual put it in the mailbox and thought it was done. So kind of the same.
Folks, do we have a motion? Are we close to a motion?
Jarrell, could you help us congeal all this to a motion, and we'll agree with what you say?
Actually, the motion's easy. We're either going to approve him or it has to test. We can't mold the test.
Yeah.
So it's either the full reinstatement exam or you approve him and the license goes out.
Make a motion that we approve him and not make him test.
Second.
We have a motion and a second by Ms. Kelly that he be approved.
I'm going to quote the mailbox law rule.
All in favor say aye.
Aye.
Opposed say no. Motion carries.
I'm going to use that in my world today.
There you go. Sounds
Well,
good.
Sherelle said.
Okay, next we have a request for waiver of a
My
separate
landlord also will go with
restroom for
that.
a shop that is located inside a home. You have on your iPads the information from Ms. Angela Hurst. She had a license to operate a cosmetology shop in her home from 1990 through 2010, at which time she stopped renewing the license. She is asking to be grandfathered in because she previously was able to have her home without the restroom there, had inspections, and at that point it wasn't asked of her or she wasn't told she had to add it on. There's no real easy way to add a restroom to be separate from the house, and the statute is very clear that in order to operate a shop out of a home, a restroom is one of those items that is needed. So at this moment, I'll let you all ask about it, but there is no grandfathering period, unfortunately, with this. So it is kind of a difficult situation.
Do you know, with my brick and mortar situation, that Tennessee business law, like when you own a business, you have to be able to provide a restroom and a drink of water for any public person that comes in. So it would, that's kind of state of Tennessee that we probably considered when we put restrooms in salons.
What about the businesses that you walk in and it says restrooms are for employees only?
I wouldn't know that, but I do know that if you do brick and mortar to get it approved, be able to open, you have to have a restroom and a water fountain. And every plumber, contractor will tell you that city code or building code will not.
He's 61 years old.
We have a lot of these in-home salons that are.
We do. We do not treat them different, and by saying that, there's nothing in our ranks, in our we just don't flag them as being any different than a shop. So very often, I couldn't tell you how many are in home. Betty does them every day. She probably couldn't either, but we have a lot. We caution anyone opening a home for various reasons, and we say, we could give you a license and inspect you and it'd be great. And we had one very sad situation where the homeowners association took them to court, won, and she had to shut down the home cosmetology shop that her whole life planned for and built the house around.
There's
because-
definitely city, even homeowners.
Absolutely.
Neighborhood codes, city codes that prohibit a,
Right.
a shop.
And that's what this was. This homeowner code said she could not, and she didn't notice. So there's not a time, Betty, in her conversations with shopping, we don't say, here's our equipment and what you need with us, but that doesn't take away what the city or the homeowner or anything else could take away. So we've always had the restroom in there for the home businesses, home shops or salons.
And I will just clarify, there is a rule that's on point. It's 0440 0440-02-.07, paragraph 6, and it does say for residential shops must maintain a separate entrance without requiring passage through any portion of a private residence. Separate restroom facilities must be provided apart from the living quarters. So that is non-discretionary language.
So there's not really anything we can do about it, right? Okay.
We have a motion to deny. Do we have a second?
Second.
We have a motion and a second to deny. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you. Next, we have a request for an extension of the time frame to complete school. This is from Ms. Camila Walker. This is pursuant to Tennessee Code Annotated 62-3-112. A student has 7 years from the original date of enrollment to complete the required hours. Ms. Walker was enrolled in a barber school that is now closed. On your iPads on page 200, you will see the release form from the school. She started school in July of 2009 and should have completed by July of 2017. Her completion date is listed, 2016, I believe. Her completion date is listed as May 2017, and therefore any time after the 7 years, per that statute, she would have lost all of her hours. She is asking for the board to reconsider this law given that the school allowed her to continue and she was unaware of the situation.
She was in a barber program.
Yes, you'll see the name of the school and the document on page 200. It appears that she started July 21st of 09, and so she went over not quite a year, but almost.
I may need some help from Sherelle with this, but it is my recollection that even though the Cosmo side had a 7-year limitation for some time prior, I do not believe that the barber side had that same restriction, seven years and out restriction in 2009. If we may need to look that up, but it's my recollection that would be correct.
I think it was added either in 15 or 16, so it would have been right before that she was allowed to continue. I think in this case she does fall into us needing to consider it. We don't get this request often, but on occasion, when we get it, it is they just didn't continue and finish. And so we've got nothing that shows good cause of what could have happened to delay it, and so it doesn't come before the board. If it's just, I stopped going, then came back and forth. In this case, it's very likely that she meant to test and didn't, but definitely when she contacted the board to test, was confused by the fact that maybe the hours are no longer available.
She has all the hours. She just never tested.
Did not test, is ready to do so. That school is closed. What Chairman Gillihan said is absolutely right. The Barber statute did not include the 7 years. It was either added in 2015 or 2016.
It's been since
our new board.
we
Yes.
united. Yes.
Yes. It is very new because that's something we specifically mailed to barber schools to be careful with. The high school education, the 12th grade for barbers, is relatively new as well, as was that piece. And those are two big pieces for schools to know.
Falls in that crack of the timeline, right?
Yes.
Well, I'd pushing for her to take her test if she falls in that time frame.
Second.
We have a motion and a second to have her test. Any other discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. Okay, next is a request for a continuing education requirement from a master barber instructor. This is for Ms. Cynthia Washington. Pursuant to Tennessee Code Annotated 62-3-124, an instructor must complete 16 hours of an approved training program. It's at the board's discretion to approve up to one additional year extension for good cause. Ms. Washington has provided a letter sharing the tragic death of her daughter in 2015. She submitted the obituary. Ms. Washington, after the death of her daughter, moved to Texas to be near family, and that is where she kept up with her instructor license requirements, not thinking that when she moved back to Tennessee, she would need to do anything different. The barber instructor requirements in Texas do not require continuing education. So what happened is she stopped doing the continuing education piece and now is asking for us to allow her to take the course and not have to retest.
Maintain her Tennessee license all that time?
Her Tennessee license, give me a minute,
Because
is current. It's current through 2019, but what she didn't do is keep up. So we took the instructor part away the minute that continuing education was not provided.
She had an extension before?
No, and within barbers, that was never the case of needing at one time. As long as barbers provided good cause for needing it, we could extend it.
if she didn't maintain her Tennessee license, if she'd retired it or something, then she could be working on her Texas license, get reciprocity, and be okay.
Right.
But
right.
Not the case.
But again, at least in the barber portion, if we extend the continuing education requirement and she can take it, if the board sees fit, we can reinstate the barber once she attends a session, given the good cause.
So make a motion that we reinstate her instructor's license once she's able to attend an ongoing education session.
Do we have a second?
Second.
I have a motion to reinstate whenever she's completed her CEUs. All in favor, say aye.
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 Motion carries.
Does anyone else come forward to do any online education?
No, the University of Memphis had said they were putting it together, but they've not gotten back with me. I followed up on it one time only, so no, we have none right now.
Thank you.
You're welcome.
I did take a second to look up the law we were talking about in the previous case, and it looks like that was passed in 2015, and it does give you all the discretion that if somebody didn't finish in 7 years, you could have them complete additional courses, etc., which means you'd have discretion not to. And so you all are fine on that vote. It just took me a second to look up that law. I know you had asked Chairman Gillihan, and I was looking for it, so that's the update.
There's so many out there and so many changes, it's hard to keep them all in my head, but
yes,
some of those I do.
Next, you have a request for an extension of continuing education for a cosmetology instructor, Brittany Tidwell. This is pursuant to Tennessee Code Annotated 62-4-114. An instructor must complete 16 hours of approved training. In this case, it's at the board's discretion to approve one additional extension as well. She has not had one in the past, but she's provided a letter that says that she had intended to put her instructor license on inactive status. Because she's currently not teaching in the industry. I believe she says she's teaching, but not within cosmetology or barbering. And her letter is on page 211. And again, it appears that it's a difference. It's a matter of understanding the retirement versus inactive. And so the board does not reflect any records of anything in writing from Ms. Tidwell asking to go inactive or retired. It appears that close to when her license expired in August, she made some calls and maybe concluded that by the conversations on the calls, that's what would happen. Instructors can place their license on inactive status, which means they don't need the continuing education, but then can continue getting their cosmetology or aesthetics or whatever license they have. To retire a license means you're not working in the field at all, and so for that you wouldn't be able to practice any of it. And so again, we have nothing in writing that asks for her to put it into inactive status, so she doesn't need it. She does not want to lose the instructor piece, and as of August, what happened when the payment came in and we had no session, again, the instructor part was taken off and the other licenses mailed out.
Asking for an extension?
She is asking to be allowed to go on inactive status for her instructor part. And we do that normally when they ask in advance, but I believe the board could.
Rather than use an extension.
Right, because she's not going to be teaching anytime soon. What she probably doesn't want in case she goes back to the industry is to have to test when she does need it. And if that's the case and we move it to inactive, she would need to complete a continuing education class before she came back to active. That's correct. We don't have many of these either. I think for a while.
We have no history of doing this before?
Pardon me?
We have no history of doing it, no precedent?
I cannot think of any. I mean, it's just, we need something in writing letting us know you want to go inactive, but there again, I think we view things a little bit differently now. I mean, she's actually teaching, just not in our industry, so she's an instructor. Her email explanation makes it sound like she had several conversations, but the confusion between inactive and retired, she might have just thought that those conversations took care of it and not that she officially needed something in writing. I don't know for a fact if she was told to put something in writing. I would imagine anyone on my team would say, we need you to decide and send something in writing, but I couldn't guarantee that.
When was the date that she wants it backdated to?
We would not backdate it. Well, so yes and no. August 31st is the expiration date of her license. And so right now, her license is active through August 31st, 2019. She would have needed to have let us know that she wanted to go inactive prior to August 31st of 2017.
I wonder if she's worked in the industry during that time.
She says I think her letter says she's teaching kindergarten and first grade.
So her cosmetology license is active.
Yes.
It's her instructor's license that she did not take the continuing education and did not renew.
Correct.
She can ask for the one-time extension, and that takes care of everything. She can make it right. She can make it inactive that way.
It's not active. Her cosmetology license.
Oh, that's right. It's
hasn't been
ask
renewed.
for the extension, take her continuing education, and then retire it. Or
ask for it to be active.
Yeah.
If I might chime in, I did find this statute. It's 62-4-114. Basically says an individual just has to notify the board of the instructor's intention. So I think the step of having it in writing is really a matter of board policy and just good practices. But here, it sounds like she verbally notified the board, and then she also went ahead and renewed her instructor license in August as well, which she says also indicates her intention that it be inactive. So here, I think, because it wasn't sent certified, we know not what happened to the letter that she contends that she mailed. But we do know that she contacted the board and at least verbally said this was her intention and went ahead and paid for the renewal. So my estimation of it would be that she met the statutory requirements, even though the written notification was not received timely for whatever reason.
Questions?
Place her license on inactive status.
Yes, it's still active. We simply would put back the instructor piece as an inactive instructor.
Make a motion to put it back as inactive.
I'll second it.
We have a motion and a second to place the instructor piece as inactive from August 31st, 2017. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you. Our last item under miscellaneous, and then I didn't realize Ms. Spicer was here waiting for the legal piece, so I apologize. This is an unlicensed master barber, so you've got on your iPad, starting with page 214, request to approve an original Master Barber license for Ms. Emily Meeks. Ms. Meeks had an open complaint against her for working without a license on December the 7th, 2017, during a routine inspection of a shop. Ms. Meeks has paid for the penalty associated with that complaint, and she has completed the schooling in Tennessee and passed both exams.
What is she asking for?
When we have unlicensed activity on a student or someone, I've always brought it before the board to make sure the board is okay approving it. We would be approving her license.
I see.
But she's paid the civil penalties. She's made things right. We have just a small issue with the Social Security number. It appears that she's lost her card. PSI has one number. We have a different number. So even if the board does approve until I actually can vouch for the number, but that's an administrative piece. Right now, it appears with the exams and schooling that she meets the requirements if the board will approve it.
Make the motion to approve.
Second.
We have a motion and a second to approve. All in favor say aye.
Aye. Aye.
Opposed say no. Motion carries.
Thank you. And my piece at the end, we will hold on because it's not long for the financial. We'll let Ms. Spicer fill you in on the legal report, and then the legal committee, complaint committee, can also answer any questions.
Good afternoon, everyone. We met
Hello.
this morning at 9 o'clock in the subcommittee. You have the legal report on your iPads. If you will note, number 1 was marked for discussion. We had some discussion about this particular complaint due to the fact that the shop has only been licensed since March of 2016. The shop license is subject to renew at the end of this month, and in 2016, not long after they were opened, they received a complaint with a $7,000 civil penalty. $6,000 of the $7,000 was for unlicensed activity. Wow. Now they have a new complaint alleging that 3 persons were found to be unlicensed. This was subject to a consumer complaint, but we did send this out for an inspection and confirmed 3 persons were working unlicensed. So we discussed the options this morning in subcommittee, and in that committee meeting we decided to go forward with a $3,000 civil penalty with a request for reinspection. If at the time of reinspection there's unlicensed activity found, a new complaint would be opened, and the recommendation at that time would be for revocation. So we can discuss this further, or the board can accept the recommendation as discussed in the subcommittee meeting.
I would accept what y'all had decided in the subcommittee meeting.
In addition, the only other change that was not discussed in the subcommittee meeting was that number 25 needs to be removed from the legal report completely. We'll discuss that complaint at a later time. Other than that, there were no changes at the subcommittee level related to the legal report. So it would be approved as amended, with number 25 being removed, and number 1, the recommendation being a $3,000 civil penalty with a request for reinspection.
Questions? Do you have a motion?
Motion to approve the legal report with the changes that Ms. Spicer went through.
Second.
We have a second, Ms. Patty. All in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you.
Thank you.
Thank you. And the last item that I have on your iPads with the full presentation is regarding our financial numbers. This is as of or through December 2017, reflecting an estimated surplus of $98,792 for the fiscal year 2018. I think the last document that we have shows the total barber and cosmetology revenue. As you've seen each month there, we reflect the total cost back that we give for the state regulatory fee. It does have November and December us showing in the red, and I just think that, as the board is aware, our fees are very lean compared to expenses, so I'm not concerned that we'll have any issue by the time we're ready to end the year. But this is one of those programs, and I think that's a great thing where we charge as little as we can to still make sure everything's paid for, but there's not a lot of excess money here. So
Are these revenues following the trends from previous years with the timing of renewals?
they are with renewals. Our complaint numbers are lower than what we've had 2 or 3 years. But I think, especially the complaint committee, we know that when there's a situation for unlicensed activity that needs to be a revocation instead of more civil penalties, we're inclined to do that. A lot of our penalties are just the $100 for the renewal, so we really have realigned penalties and even dropped numbers of complaints so that licensees are actually, we've got the licensing fees that support the board, not the complaints as much. For a while, those numbers were very heavy in complaints.
Gotcha. That's good.
I think that's the way the board also wanted to see it. When we had a lot more complaints, double or triple numbers than where we're at now, that was not a good stage or where we wanted to stay. So, and I've got nothing else. I don't have anything new under new business. If the board has anything else to discuss.
We still have the sign-up sheet. If anyone hasn't signed up for the continuing education proctoring, there's a
Didn't write down my
there's
dates.
a spot.
And I will make sure to email that final version to everyone. If you can sign up for a session that's near you, that's ideal, just so we're not paying for travel.
Yep.
But if that isn't a possibility, as long as we have a board member at all of them, I know that the providers really appreciate it. And then, of course, we do because we've got feedback. And we've got our first one in March coming up, so that'll be exciting.
Yes, we do. That'll
Yes.
be at my school.
Yes, it's your school. I'm looking forward to it.
Oh, is that Thomas's?
Thomas's class.
Is that the one we're going to?
Okay.
And for those sessions that are the smaller sessions or multiple sessions, PSI is doing a live WebEx kind of thing so that they're available to answer questions as well. Very important because of the practical exam that's changed. I think a lot of instructors are still going to have questions. So,
Is there any other new business to come before the board? Hearing none, I will entertain a motion.
Motion that we adjourn.
Second.
We have a motion and a second by Ms. Judy to adjourn. All in favor say aye.
Aye.
We're adjourned.
thank you.
Take care.
14665.
Oh, God, yes. I picked it up on the floor. I stepped on it for a minute.
I couldn't find it, and I said, she doesn't have one of those pins. I'm glad you found it.
Ellie, which one are you going to?
Well, I just